Thank you so much. Just for introduction, my name is Nolubabalo Sitsumo. I am the Acting Director for Strategic Compliance and Enforcement within Compliance and Enforcement at GDARD. So I will be giving this presentation. You can proceed to the next slide, please. The format for this presentation will be, I'll first go through, when I say the definition of wetland, I really don't mean to insult you guys, because I'm sure you have a more expansive definition of wetland, but this is the definition of a wetland that we work with as environmental management inspectors. So this is just to give a foundation that we work from. And then it will go through to just explain the EMI mandate, the functions of the EMIs, the powers that afford EMIs to protect the wetlands, then the enforcement tools that we use for the protection of wetland, and then just the additional tools and the disabling challenges that may be considered to be the reasons why sometimes we do not succeed in the endeavors that we try to engage in to protect the wetland. Just a few of those, and then just a brief cases that we've handled that affect wetland. So if we can go to the next slide, please, which is the definition that we as EMIs work with when we deal with wetlands. And you must understand that this definition is the definition that we use when we go for inspections, be it either it's a routine inspection where the EMIs are inspecting an authorized activity, or it is an inspection as a result of a complaint that was submitted for a transgression within the wetland. So before we do anything, we try and understand how the wetland is defined in terms of NEMA and in terms of the National Water Act. And you will know in the next slides why we only use NEMA and the National Waste and the National Water Act. Next, so in terms of this description of the wetland, for us, a wetland it means land which is transitional between terrestrial and aquatic systems, where the water table is usually at or near the surface, or the land that is periodically covered with shallow water, and which land in normal circumstances supports or would support vegetation typically adapted to life in saturated soil. And I'm sure as wetland specialists, your definition would then expand from this, or it will be the same. I don't know, but I'm sure it will be more or similar to the definition that we work with, because we have to be consistent in the work that we do. So if it can't be different at all. So the next slide, please. So in the next slide, I'm talking about the EMI mandate, which is the provisions that give us the powers to do the work that we do. So our mandate is within the NEMA, which is the National Environmental Management Act, the Air Quality Act, the Biodiversity Act, the Protected Areas Act, Waste Act, and the Water Act. But I think I would like to elaborate on two of these. The Protected Areas Act and the Biodiversity Act most of the time is managed by grade 5 EMIs, which may not have the same powers as the EMIs that are located at the provincial office. And also in terms of the Water Act, when we talk about the Water Act, we talk about the blue scorpions, which are situated or located within the Department of Water and Sanitation. And most of the time, the work that we do in wetlands and other water resources, we do it in collaboration with the blue scorpions. Next slide, please. So what are the functions of the environmental management inspectors? So environmental management inspectors, their functions are in twofold. either we monitor and enforce compliance with the law for which an EMI has been designated, or we investigate any act or omission against an offense, breach of the law, and breach of a term or condition of a permit, authorization, or any other instrument issued in terms of such law. So maybe for purposes of clarity, I would explain how this function is implemented at GDARD. So at GDARD, we have within compliance and enforcement, we have 3 directorates. One is called compliance monitoring and enforcement, and compliance monitoring and enforcement, their function is mainly routine inspections, what we call as targeted inspections, or then the inspections for ensuring compliance with the authorizations or permits that have been issued by GDARD. However, sometimes they would have a apologies for that. Sometimes they would have complaints that come through, and those complaints should the activity that is submitted as part of that complaint be an authorized activity, then it will be their function to go and monitor and investigate that activity. And then we go over to enforcement. Enforcement then deals with the investigations. The investigations in terms of offenses committed and in terms of prosecution for non-compliances, contraventions that were not addressed in terms of administrative enforcement actions. And in general, it will be the complaints that come through in enforcement, which are investigated by a section within enforcement. And then you have the section that I work under, which is called strategic compliance and enforcement. And the functions of that particular directorate are, they focus on both these functions, because for monitoring and enforcement of compliance with the permits, we usually deal with it in terms of the strategic projects. And by strategic projects, it will be projects that are coordinated between the province, local government, and national department, and targeting compliance monitoring of the big industries. Or it will be collaborations with the municipalities in terms of the EMI rollout to local government, where we will do investigations with them for complaints that have been lodged in terms of, but that have been lodged in their sphere, and then we investigate them and assist them in dealing with those complaints. I hope I've clarified the structure within GDARD. Next slide, please, as it relates to our function, that is. So in terms of the powers of environmental management inspectors, the powers that we have, they start from the fact that we are expected to, before we make any decision, obviously, we are expected to gather information so that we can either institute an administrative enforcement action, or we can refer the matter for prosecution, depending on the severity of the situation or the severity of the transgression on site. So for us to be able to do this, there is a procedural way that we do it, in which we do this work. So we have powers to question people on site. And most of the time when we go on site, it is very important that when we go on site, we don't go alone, because when we go alone, then we can't ask questions, and it is actually a waste of time, because whatever you get there, you cannot establish what has happened, what needs to take place, and then you will have to, it will end up delaying the decision that the EMI has to make in terms of addressing the situation on site. We can also inspect or question a person about any document or book that relates to either a transgression or a permit or authorization that relates to the activity that we are inspecting or monitoring. Copying and or making extracts of documents. Obviously, those documents we're talking about is if when we go on site, we find out that the activity that is undertaken on that particular site has either been authorized. It could be an activity that was authorized by both provincial department, or because if it's a wetland, obviously there would be documents from the Department of Water and Sanitation. So we copy those documents so that we can inspect them and investigate and get information and gather all the information that we need to make an informed decision. And we can also require a person to deliver a document. We can be taking pictures, photographs. We don't need permission from anybody to take those photographs. Digging or boreholes or taking samples, that is all the powers that we have. The beauty about the powers that we have is not just that we have these powers and then we are depending on the cooperation from the people who are responsible for what is happening on site. It's the fact that when we ask questions, we expect to be given the proper and correct information that relates to the site that we are inspecting or investigating. And in terms of the NEMA, should a person who is responsible for the site, be it the holder of a permit, be it an ECO on the site, should that person give us information that is not correct, or I wouldn't say I wouldn't say lie to the EMIs, but if the information is not correct and the person purposefully did not give us correct information, we have the powers then to charge that person. So then it gives us so much powers to be able to address the issues that we find on site in terms of environmental transgressions. Next slide, please. So then the next slide is just a continuation of the powers of environmental management inspectors, which relates to the searching and the seizure of items without a warrant. So when we suspect that there has been a transgression, then we can, without a warrant, we can go and search wherever we need to search and seize items that need to be seized as part of our evidence, as part of the chain of custody, so that should we, because when we start, even if it was a monitoring activity, when you start monitoring an activity, you have to go in that site, considering the fact that whatever monitoring activities that you're involved in can tend to be an investigation. So it is important that when you do that, you maintain your chain of custody, you protect your chain of custody. And so it's not like you monitor, and then if you find issues, then that monitoring information is discarded and then investigation starts. Investigation continues from whatever findings that the EMI was able to gather from the monitoring inspection, and for purposes of maintaining an intact chain of custody. So we also have powers in terms of the CPA, the Criminal Procedure Act. We also have powers to establish roadblocks in terms of Section 13, subsection 8 of the South African Police Service Act. However, we usually, when we do these roadblocks, we usually coordinate with the SAPS, because we have to get permission from the Provincial Commissioner of the Police, and also over and above the powers that we have as EMIs, because in terms of capacity, Gauteng has under 50 EMIs for the entire province. And you all know that that does not even scratch the surface in terms of making sure that we are able to get to all the sites. When we received complaints, we are able to monitor all the authorizations that are issued by the department, and we are able to respond to issues of non-compliance or issues of transgression that are reported to our office. So it helps the fact that in terms of the NEMA, Section 31O, a member of the South African Police Service has the same powers as a member of as an EMI. We, as part of implementing this power, the National Department, the DG of the National Department, together with the National Commissioner of Police, signed a standard operating procedure that is supposed to allow the SAPS to be able to address issues of environmental transgressions when they come across. When this SOP was signed, GDARD undertook to communicate this SOP to all the SAPS clusters in Gauteng. We obviously went to their meetings and we presented the SOP, we presented the powers, and we had examples of the items or the activities that they could help with in terms of providing additional capacity to the EMIs. However, even though that activity was done, because all the 22 Gauteng clusters, this SOP was presented to, the activities that are most easier for the SAPS we found are usually activities that deal with illegal waste dumping or illegal waste in general. I mean, illegal waste management issues in general, even though even that it does not scratch the surface in terms of really assisting. And one of the reasons that that was communicated by most of the station commanders or the major generals in all those clusters was the fact that they are dealing with a lot of litigation, and so they find that their members are hesitant in addressing a whole number of environmental issues, even though they have the powers. So when you as an environmental practitioner come across an SAPS, you could assist in getting that SAPS to assist with whatever transgression, or help that SAPS to communicate that transgression to us, because we also establish an arrangement when the transgressions are communicated to them, then there's EMIs that are linked to those clusters that they can call to go with them, and then we assist each other in terms of dealing with those issues. And lastly, in terms of these powers, is the fact that we are also also have peace officer powers. Next slide, please. Next slide, please. Thank you. Enforcement tools. So how do we go about implementing these functions? What enforcement tools do we use? So I've already alluded to the monitoring of compliance with environmental authorizations. We also, because the monitoring of compliance with environmental authorizations is in relation to Section 24F, that deals with listed activities that should not commence or continue without an authorization. And we also have Section 24G applications and Section 24G directive that deals with consequences of non-compliance. And obviously, speaking to the converted, and you know that this usually comes with a hefty penalty. And we also have Section 28 directive with duty of care, which is the most popular tool for addressing issues of most of the transgressions that we find in the wetlands. This tool and the Section 31L notice, the 28 directive and the Section 31L compliance notice notices are the tools that we use in ensuring that wetlands are protected. Section 30 emergency incidents usually deal with issues of hazardous substances that spill into a wetland, And at this stage in Gauteng, the most of those are usually sewage pipe bursts, because the way the sewage network is, it is there's no pressure, so it follows low-lying areas, and so most of them traverse wetlands. And so what we found is that there's a lot of sewage pipelines that burst on the wetland and polluting the wetland. And so we use that is section 30, and also section 30A. In most of them, if there is a listed activity that is going to be triggered by whatever measures that need to be implemented to correct the the pollution that has happened on a wetland. So section 30A is a tool. Section 38 directive is a tool that we use. And the beauty about this directive is the fact that it allows the responsible party to be able to get, even though the mitigation measures will trigger a listed activity, then that the responsible person then does not get delayed by first going to through the EIA process. Then they can get a verbal directive, which then will authorize that activity that needs to take place to mitigate the measures that needs to be implemented on a wetland. Either if, for example, in this case, if there's a sewage pipe that has burst on a wetland, and that verbal directive is usually issued within it's usually is issued between 3 to 5 days, and then that allows the responsible party to correct whatever needs to be corrected and mitigate the impact of whatever the emergency situation that has taken place on a wetland. And the section 31L notice I've already alluded to. And in cases where the pollution or the impact of the activities on the environment are so serious or significant that they can't wait for the process, then what we usually do, we go to enforcement together with our legal services, and we request for an interdict or a mandamus to get the person to stop whatever they're doing. This is usually when there's an illegal disposal of an effluent or an illegal disposal of anything into the environment that threatens the integrity of that environment. Obviously, criminal prosecution, either for non-compliance with the directive issued or the compliance notice issued in terms of section 31L, or the investigation then that took place because the matter was referred for prosecution. Next slide, please. The additional enforcement tools that we use, and I must confess that this first one has not been tested in Gauteng, and that is Regulation 8 of the government, the GNR 326 of the EAI regulations, which refers to the suspension and withdrawal of an environmental authorization. And the grounds for that is usually when it's non-compliance that has continued even though the owner, the holder of the permit has been made aware, and the administrative enforcement notices were issued and administrative enforcement actions were taken against this holder of the permit, but they still fail to comply with the conditions of that permit. And then the EMI have grounds to notify or that permit holder of the suspension of that permit pending a withdrawal, or if the permit was issued under false information and there was material information that was not provided at the time when the permit was considered, and then that provides grounds for suspension pending the withdrawal of an environmental authorization. However, as I've already alluded, we really have not tested this tool in Gauteng. We also have the section 93 of the NIMBA, which is the cancellation of permits, which usually is suggested by our biodiversity EMIs when they come across the all holders of those permits who fail to comply with the conditions of such permits. This also, in my knowledge, has not been tested in Gauteng. I've already alluded to this one of the powers of the EMIs that the members of the SAPS also have, excluding the routine inspections in terms of Section 31K and the administration in terms of Section 31L, which is the compliance notice that is only issued by the Grade 1 EMI. Next slide, please. So the question is, because we have all these powers, we have all these functions, everything looks like we really shouldn't have challenges. We should be protecting our wetlands, and the environment shouldn't be in a state that is in. So the question is, what are the challenges that the EMIs face that then makes them, for lack of a better word, ineffective in addressing these issues? Because we all know, and I'm sure you guys know better than I do, the threat on the wetlands in Gauteng is quite alarming. So with all these powers that we have, why are we not effective? The first one is we have the delayed prosecution of cases. That makes us most of the time, because if you understand the issues that happen, environmental transgressions, and maybe let me say environment is very dynamic. So when prosecution is delayed, by the time it takes place, you may not be able to prove what has happened, especially if the capacity at which it took place when the case was lodged was not as huge. Then you may not be able to prove what that impact if the case took long to be prosecuted. The next one would be the specialist evidence proving significant impact in the prosecution of cases, which is really linked to the first bullet, because most of the time when these cases are taken to court, GDARD may not have enough specialists that are able to prove the significant impact. And also because of what I've already alluded to, the fact that, the natural environment is so dynamic that sometimes it self-corrects. And if you do not have somebody who is a specialist in the field who gets involved immediately and get the information in terms of what happened, by the time the prosecution takes place, there's a lot of aspects that kind of fail us in terms of proving that there was a significant impact on the environment, and so the perpetrator needs to be prosecuted. Complications with cooperative governance, specifically between the green and blue scorpions. This has been a serious challenge for some time because of capacity, especially, well, both green and blue scorpions. Capacity is a major issue, but more specifically with blue scorpions, because they are not, the way they are structured is not the same as in the province. So they are structured according to regions. So sometimes, because they are custodians of water resources, sometimes it takes a while before you get a blue scorpion to assist, because even if you can get, because National Department always trains EMIs on a number of issues. So even if you get the green scorpions to take samples, and those samples are sent to the lab for analysis, most of the time it is the Department of Water and Sanitation that has to do those. And most of the time we tried, in order not to mess up the cases, we try as green scorpions not to overstep those boundaries, and instead we will require the blue scorpions to do the sampling, to do the analysis, because of the fact that it is mostly their mandate. The water resources, including the wetlands, are their mandate, and most of the time they have the expertise to deal with the issues that we need to address. But because of capacity, most of the time, those issues, they delay and delay and delay. And by the time you get answers, it may be too late to prove that significant impact, or there are other things that are just messing up the case. Obviously, political will in terms of taking those cases on, because we all know, I know that this is recorded, so I will not elaborate on that, but we know that where there is money, there is a way to get away with a lot of things, and it happens. It's not only in environment, it happens in every aspect of life. So most of the time is the political will to serve for this political support for the EMIs to take on, especially the big guys who, the big developers who are trying to take shortcuts and end up disposing things that should not be disposed where they are disposing them, because they are trying to cut costs of disposal, and then you end up with building rubble and wetlands and all those things. The boldness on our part as well, because if you take on these big guys, they also bring their big lawyers, and lawyers, we all know, their function is to intimidate and find a loophole. So that sometimes can intimidate EMIs, especially when it comes to transgressions in a wetland, because it is such a specialist field, it is such a specialist information that you need to prove some of the things that happen in a wetland. And so sometimes EMIs can be intimidated. The lack of collaboration among the specialists themselves, the blue scorpions and the GDARD EMIs, and also the budgetary issues. We all know some of the reasons why GDARD may not have specialists, because sometimes specialists are expensive, and then GDARD loses capable officials within GDARD that go into the private sector, and then we are unable to afford them in terms of getting them to support our findings and be our specialist in terms of verifying getting the evidence, and be witnesses in terms of specialist information that is required in court during prosecution. Next slide, please. These are just examples, by no means all the cases that GDARD EMIs have dealt with. This is just a few examples that I've extracted from the different sections within GDARD. So you can see what happened there. It was the pollution of the wetland, and after our enforcement action on the right-hand side, you can see what after all that rubble was removed, and then the vegetation then started growing within that area, and so that area was getting rehabilitated, which is also, it also speaks to the fact that once all those illegally disposed waste material on a wetland is removed, the environment is able to cooperate and get itself back to what it's supposed to be. The next slide, please. These are also other examples of these are three photographs, and then just showing the improvement that took place after the enforcement action was instituted in that area, and how the area was rehabilitated and assisted to go back to an acceptable standard. The next slide, please. This slide is also, it speaks to the same thing. These are cases that we received of builders' rubble or clearing that takes place within a wetland without um, any approval, without basically a commencement of an activity without an authorization. We know that no activity should take place within a wetland, but in cases like this, we definitely have to manage it and make sure that we get the wetland back to where it's supposed to be. So these are the cases. This is one of the cases that we handled as GDARD EMIs. Next slide, please. I think this is my second last slide. And preaching to the converted, a world without wetlands is a world without water. And we know that because of all the climate change issues, the kind of flooding that we've experienced in Gauteng during our heavy rains, it is indicative of the fact that some of the protective features that we should have, which are wetlands, because wetlands assist in preventing cases of flooding. Because we've destroyed so many of them, we've lost that protection measure, and also just the pollution aspect of the water resources because we have polluted or we have destroyed our wetland. So it was just a message to show that we understand where we're supposed to be, even though we are where we're supposed to be. Last slide, please, and that's the end. Thank you.